Welcome to the Tax Alpha Solutions Podcast, hosted by Matt Chansey. Matt is a tax consultant, author, and certified financial planner with almost 2 decades helping his clients grow their net worth. On the show, Matt brings together an array of specialists to share with you their experience and success along with strategies of the 1%. Matt Chansey is with Coastal One, member FINRA SIPC. And now, here's your host, Matt Chansey.
Good afternoon, everybody. Today, this is another episode of the Tax Alpha Podcast with Matt Chansey. Thanks so much for attending. Today, I've got a special guest. We brought an attorney on that is from Port St. Lucie, Florida, an estate attorney, and likes to help keep wealth in the family. And when not keeping wealth in the family, also an adjunct professor teaching and passing on all the years of knowledge and wisdom. But it's Jamy Barreau. Thanks so much for coming today, Jamy. Glad to have you.
Thanks for having me.
Absolutely. Glad you could be here. Well, look, I think everybody, especially people that have accumulated things in their lifetime, right, that have established wealth, and even the people that haven't, right, they have people that they care about. They have people that they love. And at the end of the day, when we're not here anymore, we want to make sure that the things that we have, we've accumulated in our lifetime that are valuable to us, whether they're valuable to anybody else or not, we want to make sure that they get in the right hands of the people that we care about. So how did you pick that profession? What drove you to say, I want to help keep wealth and important things in the family?
Well, it's funny because that wasn't my initial trajectory when I decided to go to law school, right? But really, after coming out of law school and working in the field, talking to clients, I started to see that there was a trend with my clients down here back home in Port St. Lucie, where their loved one would have passed away. And it turns out there's a lot of bickering amongst the family, a lot of hearsay when it comes to what, mom's wishes were after they passed away. And you know what, to know that we could save on the headache down the line ahead of time, that told me that, this is where I need to be. That I think this is where I could do the best good for the community.
Yeah, I hear that. Well, I think going through the death of a loved one, especially if you have siblings and other stuff like that and in-laws, it's the fastest thing I've ever seen turn an in-law into an outlaw.
That's true. That's very true. And, it kind of gets messy when you're dealing with, blended families and things of that sort. Let's take a gentleman, that I knew in the past. He had his family, his wife, second wife, and didn't have a will. And really what he wanted to do was to make sure he set aside something for his stepdaughter. But unfortunately, if you don't do that ahead of time, that's not going to be accomplished. Thank goodness we got in, we handled that before, he passed away. But that's just one of the things, folks don't know. No matter how close you are to somebody, the law doesn't necessarily say that person's next in line for your assets.
Sure. Okay, interesting case that I stumbled across the other day, and I had heard of this, but I'm going to throw it at you. You have probably heard of this before. So someone shared with me a story recently that guy was on a decently wealthy gentleman, was on a second marriage, and was planning to leave his assets to a daughter from a first marriage, from his original daughter, and his second wife was trying to leave him and I guess take him for everything, right? And he committed suicide to make sure that the beneficiary designations kicked in on his stuff before the woman could file divorce and the assets bypassed the probate or anything process through function of law to go to his daughter.
Wow. Talk about extreme measures. That's wow.
Wow. Right?
Yeah.
Wow.
Wow. I can't say I've come across that in particular. But that's another reason why, planning in advance is important, right? Perhaps they could have done a prenup, postnup, what have you, and maybe that wouldn't have been that much of an issue. But yeah, I'm definitely sorry to hear something like that.
Yeah, right. I mean, we all hear the joke say, why divorce is expensive? Because it's worth it, right? I mean, that was an extension of a whole nother level of planning right there, and I guess, she's like, I think I'm going to get this guy for everything that he's worth. And he's like, I got an answer for that, right?
All right, I'll show you. Wow.
I'll show you. Oh man, I hate to laugh at somebody else's misery, but I mean, because a lot of people wouldn't think that, but and you can speak to this, I'm sure, that a beneficiary designation on an account, whether it's a retirement account or an investment account or whatever, those avoid any type of a probate or dispute process like that, because it's function of law and it would pass to the beneficiary without the other person being able to ultimately contest that. Is that kind of true?
That is true. I mean, I've seen some folks try to contest it, trying to argue, different things like, undue influence and, incapacity. But yes, that's the general mechanism of it. You set your beneficiary designation, and then by operation of law, it transfers. The same thing folks don't know, at least here in Florida, we have ladybird deeds, right? And essentially, transfer the property to yourself with a special reservation that it transfers to someone else, which is basically a beneficiary designation. And folks don't know, like that's a means by which we can avoid probate for your home.
That's right. Let me lean into that a little bit. So for people that are listening that haven't heard that, so ladybird deed is basically a beneficiary designation that you can assign to your home, to your primary residence, so that if you pass away, that your home can avoid the probate process. But which I think typically, if it's only your home anyway, maybe it's a lighter probate process. I think it's called a summary probate or something like that. Maybe you can speak to that.
Oh, yes. So we do have two main types of probate in Florida: summary administration, formal administration. Summary administration is for, I want to say, smaller estates, has a jurisdiction cap of $75,000, but any exempt property doesn't count in that jurisdictional limit. So, your homestead property, up to 2 vehicles, and there is a weight limit in there as well. But so generally speaking, if that's all you have in your loved one's estate, the homestead, a couple of vehicles, you could push that through probate rather quickly. Where you get into the lengthy types of probate is where you see, bank accounts with large sums of money in it, or rental properties, and especially assets that are, out of state or even out of country.
Right. So are there ways to put beneficiary designations on bank accounts and stuff like that?
Oh, absolutely. So each bank is going to have its own, internal processes, but generally, you fill out a few forms and you're essentially letting the bank know this is my beneficiary. And it's as simple as your loved one presenting your death certificate to the bank to receive the funds.
Gotcha. And so what's the complication? You brought up out of state. I would think that if something happened out of state, finding some of these assets would be hard. How would I know that someone had a loved one had an account in another state? How would I even know that? Like, number one. And number two, where's the complication come in with the probate process?
Well, it's interesting because that's a big thing, that I see a lot of my clients have, their parents passed away and they're not quite sure what they had, right? And in some of those instances, we might need to engage a private investigator maybe, or maybe there might have been a safe deposit box with some more clues as to where you could find some information, things like that. But where the real complication comes when you're doing a probate, let's say, the person died here in Florida and they died with assets in New York. Well, that just means we're going to need a probate here in Florida and in New York. So that's going to be tracking down, an attorney up there. And that's just more time, more effort, more money at the end of the day. When, if you do the planning ahead of time, you could avoid all of that.
Gotcha. I have a client that's in the like the estate type recovery business. So they help people that they don't normally find the person that's probating the assets or whatever, but they find family members, right? So, okay, let me back it up so I can tell this story so it makes a little bit of sense, right? So originally they were in the real estate business. And if you are in the real estate business, the goal is to find kind of the ugliest house in the nicest neighborhood, right? Like that's the opportunity. So you drive through a nice neighborhood and you see a house and the grass has grown up and the ugly and there's bushes are all grown up around it. And a lot of times that person has passed away that lived in that house. but somebody didn't know that that person passed away, or whoever their heir might have been, or they didn't have any heirs. So they started to do the research, started to find out that, yes, doing like ancestry.com and finding the tree and going, oh, there is somebody, but there's a second cousin in Indiana that we need to contact, right? So then you contact the second cousin in Indiana. You're like, you're not going to believe this, but you might be the closest living descendant of this house that's down in this area, and if you could help me a little bit, we can get you through the probate process and help you recover some of this stuff, right? So I always found that really interesting when they was explaining that business to me, but it's finding that home and then finding those heirs. So how complicated is it, or a part of your responsibilities when you're setting up these plans, is it to know who all the heirs are, and then to be able to communicate the wishes of the people putting together the plan preemptively to those heirs, so that if and when that time happens, they kind of know what to do or who to contact? How much of a part of it is that?
Oh, that's a huge part of it, because you're probably one of the biggest parts, right? So one of the biggest parts is figuring out what you own and listing that out appropriately. But yeah, you really want to make sure you know who your assets are going to. And I tell my clients I deal with what ifs, right? So yes, you may want, your watch to go to your cousin, your favorite cousin. But what if your cousin passes away before you? So it's good to have contingencies down the line, so that you don't run into that issue of, us having to track your 16th removed cousin to make sure that your property can move forward. So yeah, it's a huge part of it.
Sure. Gotcha. Yeah. Helping them understand. Because if they don't know where to look for the stuff that you have, right? Like, what are you going to do? It's a needle in a haystack type situation, right?
Right. Exactly. So having a good inventory is important. Absolutely important.
Do clients have reservations about sharing the inventory of the stuff that they own with people that might be the beneficiary of it while they're still here? Does that bother people?
I've gotten mixed results, mixed concerns about that. Some parents are like, oh, I trust my children indefinitely, and others are like, let's put this in the safe. They'll find out later on. But essentially, yeah, it's pretty mixed. And that makes me think of something that I was dealing with a client recently, and they didn't understand just how much trust you have to put into the person you're designating in charge of your estate. Here in Florida, we call them personal representatives, or even a trustee if you're doing a trust. They didn't realize just how much power they had over your estate. And that just made them think like, wow, I really should pick somebody I trust. So all of these things are important concerns that we go over in the estate planning process.
Gotcha. Understood. So you brought up something there. You said, we've talked a little bit about beneficiary designations and ladybird deed, and these are tools that, are part of the estate planning process. And then you just talked about trust, right? So personal representative and a trustee. So when would somebody potentially want to use a trust? And this isn't a legal conversation, so we're not going to hold you to it. Just conceptually, right? At a much higher level, when should someone start to think about a trust and it might be a good idea for what they're trying to do?
Well, there's a few different reasons. A lot of my clients, their biggest concern is controlling what happens with their assets long after they pass away. So they kind of want to pull the strings after they've died. And a trust is good to do that, but there's other important parts of trust too, right? So I help a lot of clients get set up with Medicaid planning, and irrevocable trust play strong roles in that. If you're dealing with high net worth clients, you may want to discuss whether an irrevocable trust might be important or helpful in sheltering some of their assets from, estate taxes, federal estate taxes, at least. That's my only concern here in Florida. With the current exemptions and everything, it's not really too much of an issue, terribly, depending on the clients you're working with. But essentially, the trust is going to really depend on what your goals are. But I tell all my clients I'm a strong advocate for a trust-based plan, because, unlike a will here in Florida, a trust, having your assets in there would help bypass probate altogether. So it's just another means of accomplishing that goal of avoiding probate.
Sure, makes sense. So I heard you talk about Medicaid planning in there. And so Medicaid planning, the way I understand it, and I'm going to let you correct me, is, I've got my assets over here like this, and then I need some form of long-term care or whatever, potentially in a facility or from the state or whatever, because I think it's a state administered program. And the state has guidelines that says if my income is under certain thresholds and my assets are under certain thresholds or positioned in a certain way, that I might be able to qualify for the state to pay for my care. So it's a function of either naturally just almost kind of going broke, right? Or repositioning some of your assets to use some special circumstances and planning so that the government will say, hey, we see what you did there and we'll step up and we'll help out with the bill. Is that a thing? People doing that?
Oh, yes, absolutely. People are, it's really important because when you think about long-term care, without that program in place, a lot of people would be spending up their hard-earned money just so that they can receive the care that they need. And there's a lot of, I've run into a lot of people who kind of consider it a little taboo. They think they're getting a handout, when really, no, you worked into the system, and it's just about making sure that you receive the care you need while sheltering your assets for the next generation to come. And I think that's the biggest thing, the biggest motivator for my clients who decide to go through Medicaid planning, because they would rather their children get the benefit of their assets rather than the state or a healthcare facility.
Well, you worked hard for your money, and if there's an opportunity and it's in the code and you can keep money in the family, it's just a function of knowing more, right? And knowing how the program
Exactly.
works and being able to act. So are there some assets that are potentially exempt from like the Medicaid spin down process?
Absolutely. So your primary residence, that's a big one. That's exempt from the actual application process, as well as, let's say you have other properties like rental property. So income producing assets, those are exempt as well. And in terms of transferring assets, let's say we're trying to go the route of an irrevocable trust to shelter some of your assets. By transferring to an irrevocable trust, you do run into the gifting issue and possibly being penalized depending on when you go ahead and apply for Medicaid. So it's good to know these things ahead of time, before you start actually applying. But where I'm getting at with that is you could also transfer any amount that you'd like to a spouse to shelter it in their hands, and there's no penalty for that. So, there's different exemptions and different strategies that we could approach it with, but those are the top ones that come to mind.
Okay, yeah, makes sense. All right, so primary residence, and you can, income producing assets. That was it. So, like, if you own rental real estate per se, and it's generating cash flow from it, that's can be an exempt asset.
Correct. So the actual asset itself, the home, the rental property, will be exempt. But what you need to look out for is the income coming in. So if that ends up putting you over the income threshold, then we'll have to um, engage some other, means to make sure that we get your income down for, the Florida limits and everything. But yes, income producing property absolutely would be exempt.
I've heard before that there are some types of special income trusts and stuff that can catch that income and kind of obfuscate it from the application per se in a legal way, right? Right? Is that
Exactly. And in a legal way. Because one thing that's important for everyone to know is that these are, provisions and strategies that the government has outlined for us to use. They basically said, giving us permission to do this. And essentially, those types of trusts, those income trusts, qualified income trusts, they'll receive your income, and essentially it'll say, yeah, we'll disperse some to you, for things that are generally outside of what the long-term care Medicaid is going to cover. And that's a bird's eye view of how that works.
okay? Okay, understood. Makes sense. I'm familiar with how I've heard it before in the past. So if you give assets away, I remember back in the day, I'd heard of this because I had some grandparents that went through this process a little bit. So I was somewhat familiar from back in the day. There was like a 5-year rule or something. Does that kind of stuff still exist?
It does. So when you're going to apply for Medicaid and you're trying to move things around, it's important to know that if you're gifting anything, getting things out of your name, the Medicaid office is going to look at that and say, okay, well, within the past 5 years, if you gifted anything, they're going to penalize you for that, just because that's not one of the means by which the government has outlined that you can appropriately shelter your assets. But there's different strategies to it. So if you're gifting to your spouse, that's something completely different, like I mentioned before. But the main goal, if you are in an emergency situation and you have to bite that bullet and say, okay, well, there's nothing else that I can do, I'm going to take the hit for the penalty, that's one thing. But we have so many different options that we can do, like a caregiver agreement, things like that, where we can really maximize the Medicaid planning process so that we can avoid the mess and the pitfalls of the penalties.
Sure, understood. Caregiver agreements. I used to hear back in the day there was something like a personal services contract. Is that kind of in that same ballpark?
Exactly. So essentially, if you have one of these caregiver agreements, personal services contract, essentially, and it's different in every single state because it's state administered, as you said, but in Florida we do accept those, and it's just a means of getting wealth over and sheltering that wealth to allow you to qualify. And essentially, let's say, for instance, you had your daughter taking care of you long term at home. The personal services contract could say, hey, I'm going to transfer all of this money to you as payment for your services as my caregiver. And the Medicaid office takes that and understands, okay, well, this is an exemption from any penalties. And we use that, although it's very important, we could use those in, emergency situations when we need to get somebody in quick.
Sure, sure. And I mean, a daughter would take care of a mom or a parent anyway. That's just something they would naturally do. So if compensating them a little bit for it, do it. And it also helps us qualify for something. It seems like it's a win-win, right?
Exactly. Win-win. Absolutely.
So I've heard before, what about veterans benefits? Are there any type of veterans benefits that coordinate or work together with some of these potential Medicaid programs?
There are VA benefits, and it is possible to in some situations to take advantage of all of them at the same time. But it really just goes into, all the qualifications for the VA benefits, whether you qualify. But that is a service that my firm does provide, but it all comes down to a case by case basis.
Gotcha. So is it all planning that you guys do? Because it sounds like there's a lot of planning and kind of moving stuff around a little bit legally. But then I think if I remember the process there's an application process to the state that you have to file or whatever to be kind of accepted into the program. Is that part of the overall service?
Yes, it is. So we do help our folks get, through the approval process and, answering any questions that the state might have. But ultimately, that's the extent of our services here. There are different elder law firms who really specialize in, appeals. So let's say, you apply and, you get denied. It's not really for a good reason, or at least there's a good argument behind why you should be, approved. There's different law firms that specialize in going to the government and appealing those. But my firm is limited mostly to the application process.
Okay, understood. So let's look at the other side of the coin. So we talked about people maybe not getting older, health not so good, needing a high level of care, income and assets not necessarily all that high that they can cover or self-insure on that, and looking for government benefit qualification. The other side of that, which is probably certainly lesser people to deal with, is the estate planning side, right? I mean, today as a married couple, isn't it like $23 million that you can have in your estate before you pay estate taxes?
Right. And I mean, that law, the Tax Jobs and Cuts Act, I think
Tax
that's what
Cut and
it
Job
is.
Act, TCJA.
There you go. I was switching it around. I believe that provision is supposed to sunset in 2026. But yeah, that's basically what it is. It's a pretty high threshold, especially when you're dealing with, your run-of-the-mill clients. But when you're getting into the high net worth clients, once you start getting, over that exemption amount, it's time to start thinking, what high level planning can we do to I don't want to say hide your money from the
Sure.
government, but certainly move it with taking advantage of the tax laws that are out there.
Sure. Well, look, it's not, people might look at this all day long and say these are loopholes or, whatever, but it's in the law, it's in the code. These are just understanding the rules of the game and knowing how the game is played, right? And we just talked
Exactly.
about people that are on the lower end of the income spectrum being able to move stuff around and have the government pay for your long-term care. Why is that loophole any different than a wealthy person moving it around a little bit and not paying estate taxes? It's similar, right?
Exactly. I think at the end of the day, the way to look at it is safeguarding your assets for the next generation or even generations to come.
Sure.
And it's just, taking advantages of the law, the permissions that we were already granted. That's all.
That's right. I learned a long time ago that every dollar that somebody has is every dollar that somebody has, right? And they look at it the
Mm,
same way, whether it's 10,000, 100,000, a million, or 10 million, it's all that they have, and it
right.
matters and it's sacred to them and their family the same way, right? So,
Hmm.
people don't run around counting other people's chickens all the time when it's at the end of the day.
Right. Very true.
You're like, these are my chickens, and I want to make sure they get to who they get to, right?
Right.
Understood. Good stuff. So, legislatively all the time, every time we hear so we had the Tax Cuts and Job Act, TCJA, and then we just had the Inflation Reduction Act. And, constantly hear this political struggle back and forth talking about, taxation. It's always a hot button or whatever, a talking point in the political agenda. They've been trying to cut some of these estate tax benefits. Did any of that get impacted one way or the other in the Inflation Reduction Act that just came out? Were some of those being talked about? Are they on the chopping block in the future? Where do we see the ball going?
I haven't seen big changes with the new law that came into effect, but I've heard a lot of talk about changing it. Let's say, what we were just talking about, the exemption amount, and changing whether or not we get that step up in basis after someone passes away in certain assets. But I haven't seen that implemented just yet. But there has been a lot of talk.
Gotcha. Well, so you brought it up, right? There you go, using fancy industry terms. So stepped up basis, like explain to listeners if you're unfamiliar with that concept, what is a stepped up basis?
Well, when you're dealing with, let's say you buy a property, let's say, you paid 50 grand for the piece of property. If you go and sell it next year for 60 grand, and just trying to use smaller numbers here, you're going to pay, capital gains tax essentially on, well, let's say you sell it in 2 years, just to make it simple. You're going to be paying capital gains tax on that $10,000 gain. That initial purchase value is your basis. However, if you were, let's say you purchased a home for $50,000 and then you kept it, you were there with it for, another 10 years. And when you pass away, it's valued at $100,000 and you gift that in your will, for instance, to your kids. And if your kids turn around and sell it that same day they inherited it for $100,000, they're not going to pay any capital gains tax on that property. So essentially your basis is stepped up from that 50,000 to the value of your death at 100,000. And that's probably, a very basic way of explaining it, but that's a big benefit in our tax law. And, a lot of, the new administration that came in, they were talking about, putting that on the chopping block, removing, that step up in basis, I should say.
Sure, sure. So how many beneficiaries or heirs, right, or people that go through the probate process when they inherit real estate or investments or whatever, how many of them think they owe a bunch of taxes on all that stuff?
I will say this. A majority of my clients are concerned about whether or not they have to pay taxes on, assets that they receive or whether they sell it. And one thing that I can say, at the federal level, at the Florida level, we don't have an inheritance tax, right? So just by the act of, receiving property that you've inherited, you're not going to be charged a tax for that. It might be different in other states, but at least that's my experience here.
Sure, sure. I think one of the biggest assets that may or include taxation, and I'll let you speak to this, is what if somebody inherits an IRA from somebody, right? Are there rules around if my parents had a 401k and it later maybe became an IRA and then they pass away and I ultimately inherit that? What are the tax ramifications? What can I do with it? What are my planning opportunities?
Well, there are opportunities. I understand that you can roll over some of the IRA amount, but if you were to cash it out, of course, you're going to be, taxed on that, on that money. But
Do they have to
it's just
cash it out?
so no, they don't have to cash it out. They can roll it over and take it over themselves as long as they're a qualified person to do so. So it's just another means of, receiving future wealth and being able to use that and move it forward.
Sure, makes a lot of sense. I get it. So, well, interesting. So we've talked a little bit about. So okay, so we've talked about Medicaid planning. We've talked a little bit about some of the planning for the high net worth. So let's give a strategy. Let's give an idea. We talked about a personal service contract and income producing real estate on the Medicaid side. Let's talk about name off a planning strategy or two that somebody on the higher end with an estate tax issue might want to consider. What would be a couple of the tools that they would look at?
Well, some tools that they could look at if they're looking to minimize their estate tax liability would definitely be finding ways to spend down their money in ways that they're not going to be taxed on, right? So we do have a gift tax as well as an estate tax. So some things are exempt from that, right? So if you're paying for, someone's tuition, whether it could be, at the grade school level, but, thinking about college tuition, that could eat it down some, and that's exempt from gift taxes. Paying someone's medical bills, things like that, that could be done as well. And certain types of irrevocable trusts would accomplish the goal of minimizing the estate tax liabilities, but it just all goes into, which one fits right for your situation. Even if you have a philanthropic client, you could get some tax benefits from some charitable donations and things like that. So it's all going to come down to, what the client needs and, what their ultimate goals are. Because I think we can craft a plan around those that's going to accomplish the ultimate goal of minimizing tax.
Okay, understood. Makes sense. Makes sense. So let's talk about in your practice, right? A little bit. We all have fun stories or interesting stories, right? So I remember back in the day, I had an estate planning case where mom went into a nursing home and there was a son and a daughter. And the son literally went and stole mom out of the nursing home and moved her and put her in a back bedroom in his house. And he believed that if he physically possessed mom, that he would be able to have access more of her stuff if and when mom passed away, right? I believe if he physically had control of mom. Now,
My goodness.
that is crazy. And by the way, mom died in his back bedroom because she wasn't getting the level of care ultimately that she needed for being there, right? But that you could see how that type of a story would drive a wedge between, a son and a daughter, right? When one of them treats mom like that. So do you have any interesting stories? Maybe that's kind of a bad story, but a little bit funny, in a way, but maybe on the other side of the ledger, maybe you have like an enlightening story where you help somebody put together and put some plans in place. So any stories to share?
Nothing too in particular. Maybe more so, a highlight of how, sour things like probate can get, right? So I was once handling a probate where, I represented the oldest son. Mom had passed away, oldest of seven, and mom actually had a will that said, I want all my children to receive my home. I worked hard for my home, nothing strange there. We get to probate and we get in front of the judge, and it was the first time I've had a judge deny the request of the decedent. And the judge said, I don't like the idea of seven people owning a piece of property together. They're not going to agree on what to do with it. So luckily enough, we ended up handling things amongst the siblings, and everything was worked out. But it's something that I think of whenever a client asks me, should I do a trust or a will? Because if it was a trust, there wouldn't be anyone stopping them. The judge wouldn't have a say. There would be no discretion on the part of the court. So it's just more of a highlight of, why it's important to pick and choose the right plan.
Well, if you don't pick your plan, Rate picks one for you, right?
Exactly. Exactly.
And when was the last time we ever like somebody else picking something for us, right?
That's right. That's so true.
Understood. Well, hey, you talked a little bit about at the beginning when we first started that you do some teaching and as a little bit of an adjunct professor type thing. So I don't want to just assume that you talk about estate planning. Like, who do you teach and what do you teach them? And what got you? How did you? Where'd you start moonlighting as a teacher? Where did that come from?
Yeah. So, I kind of fell into it. It was, right time, right place. I primarily am teaching business law right now. But, even with business law, it does, have implications of estate planning, right? How do you get your business to the next generation? How do you make sure your business operations aren't interrupted during the time of the transition of, power, I should say. So it's just, I like to highlight these things and really just lay the foundation for the students as they move forward and get into their careers.
Yeah, good stuff. I mean, look, it helps knowing, what do they say? Always start with the end in mind, right? And the end in
Yes,
mind could be some estate planning. And I guess from a business perspective, estate planning is succession and key man, right? What happens if we wake up, dress up, and show up every day? Our business will probably be fine. But
right.
if death, disability, divorce, or sickness or something like that happens, then hey, you throw this big monkey wrench in the plan. Who last thing I want to do is be in business with your wife. I probably didn't
Hmm.
like you as much as a business partner as you thought I did, and I certainly don't want to be in a business with your spouse.
That's right. There you go. Exactly. So all these things you got to think about them, and it's interesting to see just how far estate planning and that realm, that area of law, just reaches into other aspects of life like that.
Yeah, understood. Well, Jamy, this has been a fun time. I appreciate everything you're sharing. What didn't I ask today that I should have asked that we should be sharing with the listeners?
No, I think we covered some great points. Thank you so much for having me.
Good stuff. Absolutely appreciate you being here. So, well, everyone, thanks again. This was another episode of the Tax Alpha podcast today. We had estate and business attorney Jamy Barreau on. He is from Port St. Lucie, Florida, and I think you said born and raised in that area. Didn't you tell me that?
Yeah, that's my hometown.
Floridian through and through, right?
Yes, yes.
You know what? I'm from Florida myself. I'm as many generations as you can go back, kind of central Floridian. And for the longest time, I think people used to think I was a dumb Southerner. Now it just turns out I was early. Everybody wants to be here now. We had it figured out way ahead of the game, didn't we?
Right, exactly. Now we're the hot spot.
Now we're the hot spot. Very good. Well, Jamy, thanks so much for joining us once again. Everybody, today was Jamy Barreau, estate planning attorney. All of his contact information will be listed at the bottom of the podcast. Thanks for listening. I hope you learned something today. Matt Chancey with the Tax Alpha Solutions. Have a great day.
Thank you for listening to another episode of Tax Alpha Solutions, brought to you by Matt Chancey. We hope you enjoyed listening to this week's guests and insight. If you liked what you heard, please consider subscribing wherever you listen to podcasts.